We're going to move now to who qualifies as an expert. And we heard from Matt this morning, it should be somebody else that has, then just has apps on their telephone. But that has been the experience to a certain extent in some of the hearings we've been doing before the Ontario Environmental Review Tribunal. But I'm going to turn it over now to my partner, Jim Bunting from Davies, and I've reminded him that there is a large audience watching on webinar and that the webinar will be online forever, so he should behave himself. And I'm going to remind him again to behave. And Terry the Olnick from Osler as well, and so she's sitting close enough to give him a good shot if he doesn't.
Thanks, Sarah. This is how hearings go with Sarah and I, constantly admonished for things.
I don't need to be told to behave. I'm usually pretty good. So that being said, so Jim and I today are going to talk a bit about who qualifies as an expert in Canadian environmental cases. Just by way of disclosure, I work at a firm here in Calgary, and we represent, in my practice is representing project proponents. So I don't represent interveners or government generally. So that's sort of the lens that I'm going to be giving my presentation from, so everyone kind of knows where we're coming from. So today, Jim and I are going to talk about sort of four separate things. The first thing is going to be who qualifies as an expert and what is the role of an expert in a tribunal. Second is going to be why you should care about this. You might be wondering why you should, and hopefully we'll convince you that you should and why you should. And also a little bit of an overview about our practice, or our experience has been in practicing in tribunals in terms of this area. Third, we'll talk about some recent case studies focusing on Ontario, Alberta, and hopefully nationally if we get enough time. And then we're going to conclude with some considerations for kind of rethinking the approach and some suggestions from us. So just turning to the first topic, who qualifies as an expert? Everyone. We could probably go home now. We'd be done. But basically, historically and recent experience has shown that tribunals engage in a let-it-all-in sort of approach when they're receiving expert testimony. Our view that we'll talk a bit about.
Let me just jump in for 1 second. Terry Lee has completely disassociated herself with my slides because she thinks they're cartoony, which is true. But I am going to use them behind her while she's speaking. So
if my face gets screen capped on the webinar, this has to be removed from behind me.
But this is the let it all in. Sorry to interrupt you.
This hasn't been my experience. Mine's a little bit different, a little tamer, still wild, but not quite the gaming experience. So we're going to talk about why our view is that this approach, the let-it-all-in approach, presents difficulties and some challenges, not just for project proponents, but also for interveners as well as the tribunals themselves. One thing just to remind everyone of, if you don't practice in this sphere, is that tribunals aren't bound by the strict rules of evidence like courts are. It's quasi-judicial, it's not judicial, so they have a great deal of flexibility in terms of how they exercise their discretion in choosing whether or not to allow people in or out. And one thing that's been remarked on by the Alberta Utilities Commission is while a tribunal has flexibility, it cannot ignore the principles that underlie the formal rules of evidence. So kind of with that in mind, we'll just turn to what expert witnesses should be guided by and how you should think about an expert witness. And again, just turning to the Utilities Commission, some recent comments by them. First of all, in terms of presenting an independent and unbiased expertise, so an expert witness should provide independent assistance to the court, or the tribunal in this case, by way of an objective, unbiased opinion in relation to matters within his or her expertise. So that's a pretty loaded sentence, and we're going to go through what that means and how that actually looks. Expert witnesses are to be held to a high standard and must fully disclose the kind of relationships and history that might lead to a concern towards bias. And we'll talk again a bit more about that. And such a finding would generally lead to an adverse inference on the impartiality and character of that expert witness. The second sort of principle that the Utilities Commission recently talked about was the scope of expertise. So again, going back to experts being qualified to opine on those areas that are within their expertise and not straying beyond that. If they stray beyond that, tribunals have held that they will be given the weight of a layperson. So no different than anybody else just coming to simply testify about it. And the third thing is that they're an expert. They're not an advocate. We're the advocates. We're paid to present positions and argue positions. They are not. They are not paid to argue outcomes. They're there to provide expert opinion. So now turning to why we think you should care and what our practice has been, Jim.
Yeah, so just to emphasize one point there, the slide behind me, again, cartoony, but makes the point. The role of the adjudicator is to serve as a gatekeeper when you're dealing with expert evidence. And that's incredibly important. Experts have the potential to cause great harm to the adjudicators if they aren't actually properly qualified experts, because the trier of fact is relying on them to give them independent, impartial, objective opinion evidence about areas that are outside the expertise of the adjudicator. And if you rely on someone who you think is an independent, impartial expert and accept their opinion, and it turns out that they're not, great harm can be invoked. In Ontario, there was an inquiry done into pediatric forensics, and there was called the Gouge Inquiry. But effectively, just to put a point in it, somewhere around 10 parents were wrongfully convicted of murdering their children because the proper rigor wasn't applied in deciding who's an expert. So that's the starting point from a commercial litigation perspective, whether it's an administrative tribunal or court, is it's incredibly important for the adjudicator to fulfill that gatekeeper function. And our experience has been instead that there is a bit of a let-it-all-in approach that Terry Lee was referring to. And the Ontario Court of Appeal actually has coined the phrase "let it all in." And it's something that adjudicators do. They'll hear the objections to the admissibility of the expert opinion, but then they'll hear the evidence. And there are some dangers with that. It's not always inappropriate to do that, but there are some dangers that follow from it. So what we're going to do now is a bit of a case study review of some of the evidence that we've seen over the past 2 years, I think, primarily in wind turbine projects that have resulted in hearings. And I say case study, although Terry Lee and I agree it's actually more of a witness study, because there are certain witnesses that have appeared repeatedly in hearing after hearing after hearing opposing wind development. So we're going to start with somebody by the name of Rick James. Rick James is an acoustician, meaning he's a noise expert, and he testified in a number of cases supporting the position of people who argued that wind turbines cause harm to human health. And he's what I would describe as a serial expert in that he's testified repeatedly, including in the Blue Earth Energy case before the Alberta Utilities Commission, and in the Erickson, St. Columban, K2, and Armagh proceedings, all before the ERT in Ontario. I'm sure I've missed half a dozen other cases where he's testified. His independence was challenged in pretty much all of the cases that I've seen, although not aggressively until about a year ago. His evidence was admitted, but given varying degrees of weight. And his independence was challenged quite strenuously in the K2 wind project before the ERT, and subsequently in the Armagh wind project before the ERT, which are cases that Sarah Powell and I were involved with. And it's an interesting contrast when you look at what the tribunal did with Mr. James's testimony. So let me tell you a little bit more about Mr. James so you can understand how the tribunals are applying these rules. Mr. James, since 2005, has represented about 30 clients in matters involving industrial wind turbines. It makes up 90% of his business, and he's never once acted for anyone who supports wind development. Not necessarily a huge deal. You see that from time to time. But he's also the founding member of the Society for Wind Vigilance, which has publicly called for a moratorium on wind development. He also agreed during his testimony in the K2 and Armagh proceedings that he was acting as an advocate against wind development. And he also testified that while he's not against wind development in total, he's never seen a project in Ontario that would meet his standards, and he couldn't tell us what the safe setback distance was for a wind turbine from a home. That's his sort of lack of independence, and then it actualized itself in his testimony. We saw him use hyperbole, advocacy statements, and exaggeration in his testimony. And I have a slide to try and illustrate that. So what do all of these pictures have in common? Each of these pictures is a way that Mr. James analogized wind turbine noise. He says that the low-frequency noise generated from wind turbines is the same as the low-frequency noise you see in the natural environment from hurricanes, tsunamis, and tornadoes. He testified that the spikes in noise that you see in low-frequency noise are like a gunshot. And he also acknowledged in cross-examination that he had testified in another case where he compared the noise from a wind turbine to like standing on a World War II battleship with a kamikaze plane flying towards you. So these are some of the statements that Mr. James uses when he testifies, and in my view, they show pretty strongly that he's acting as an advocate and he's not independent. So what happened in these cases when we challenged his independence? Well, first, as a procedural matter for timing reasons, we challenged his qualifications while we cross-examined him on the merits of his opinion. So we expected the tribunal to rule on whether he was a properly qualified expert in its final decision. And one of the reasons for that is, as you can see, it's helpful to cross-examine him on his opinion and get out this kind of evidence because it shows what it means. It shows quite strongly how he's not independent. Now, in the K2 case, his evidence was accepted, and no ruling that I've been able to find in the decision was actually made on his qualifications as to whether he's a properly qualified expert and the evidence should be admitted. But implicitly, the tribunal accepted it because his evidence was considered, although given less weight than the evidence of the other acousticians. In the Armel proceeding, the tribunal went further, and they actually made a ruling in their decision on his qualifications. And you'll see their finding about Mr. James on the screen behind me. They found that his independence was equivocal. They found that his evidence was selective and not forthcoming about the actual state of science. They found that he failed to modify his witness statement after it had been shown to be inaccurate in a previous tribunal hearing, and also that he used alarmist language, which suggests that he was acting as an advocate, and we've seen some of those images. So a couple sort of conclusions come from those two cases, I think for myself and for Terry Lee. And the first is the K2 case, the tribunal should have made a definitive ruling on whether he was a properly qualified expert, and if he was, whether they were giving his evidence less weight because of his lack of independence. And then in the Armel case, I would pose this question: should the tribunal have gone further? Can an expert, and you'll hear from, I think, the next panel of speakers, expert testimony has to be independent and impartial. Can someone be an expert if their independence is equivocal? And I would say no, they can't be an expert if their independence is equivocal. And in my respectful view, the tribunal should have gone farther here and given his evidence no weight or not qualified him as an expert at all. Terry Lee, do you have any thoughts or comments on Mr. James? I know you dealt with him in the Blue Earth case.
I do have a lot of thoughts. So just to jump back for a minute, so Jim's talked a bit about the Ontario Environmental Review Tribunal and kind of what happens there. I thought I'd just give a short overview of what happens at the Alberta Energy Regulator, the Alberta Utilities Commission, and at the National Energy Board in terms of experts and how that works. And often experts aren't qualified at all. In some proceedings, individuals are clearly tendered as experts. Their curriculum vitaes are filed, they present that sort of evidence, but they're not formally qualified, whereas in others they are. Generally, if they are, it happens at the start of an oral hearing after pre-filed written evidence. So unlike the ERT, there is no direct evidence that's tendered at any of these proceedings with the exception of a brief opening statement occasionally. So that's kind of the way it works in front of those bodies. In this particular case that Jim was talking about, and this is Blue Earth Renewables Bull Creek project, which was proposed. It was the largest wind project in Alberta, and it had a 2-week hearing. So at that proceeding, the AUC took a very rare step in seeking to pre-qualify witnesses in advance of the oral hearing commencing. So that was a little bit different, and so. Several experts were challenged on primarily this basis, namely that they were members of the Society for Wind Vigilance. And as Jim kind of posed the question, can a person be an expert if they're not independent, if they're not objective, and they're potentially biased? Does it matter if their opinion hangs together and does sound sort of scientific, or is the fact that there's that potential for bias enough? Just to throw them out. So that was the argument that was made in that case in the pre-qualifications. It was unsuccessful. The AUC admitted everyone that was tendered as an expert in any area that they indicated they were an expert in. So that was done in advance of the proceeding. And one thing to note also is that just this last summer, I think it was, in another proceeding, the AUC indicated that they were reconsidering their approach to experts and considering not qualifying anyone at all to get over the need of fighting about experts. So it looks like they're really going for the all-in approach in the future. But again, so when we dealt with that case, so this individual was allowed in as an expert, and of course we went over again his membership in the Society for Wind Vigilance, and in the result, some members, some experts who were members of that organization were given little weight in front of the commission. But at the end of the day, they did testify. They did provide evidence. The proponent had to pay for certain costs related to those individuals attending, because costs are awarded before the AUC and the AER. So it kind of, it went pretty far, I would say, in terms of experts, and it looks like that's kind of going to be the way that it is.
Yeah.
I guess one final note I would say is that in the commission's decision, although they gave little weight to some of these individuals, they did indicate that they were not prepared to disregard the evidence provided by him or the other experts solely because they were members of the Society for Wind Vigilance, which again advocated a moratorium on wind development. And then the commission went on to say, nor was it prepared to disregard the evidence provided by the applicant's witnesses because they have previously testified on behalf of other wind developers. So if you think about that for the second, I don't quite think that's the same thing. Because you've only represented wind developers is the same thing as being in an organization where you want to stop all wind development. I don't think you can quite equate those two things. But anyway, that's where the commission went with that.
And I just add one last comment before we move off Mr. James, because it came up during his testimony. But we've talked about why it's important for the adjudicator to serve as a gatekeeper. One thing that became apparent to me during the course of these hearings was the public hearings, and there was an audience of 40 or so people at both the RMAO and the K2 proceeding. And it was a rambunctious audience who was strongly against wind development, and they would cheer for Mr. James when he said things they liked, and they would heckle me when I asked him questions they didn't like. And one thing that I thought about when we finished the evidence of Mr. James is if he's not a properly qualified expert, if he doesn't truly have the requisite level of independence that our courts say an expert must have, are we inflicting any potential harm on the public by letting someone testify, and in Mr. James' case, from time to time, testifying on areas that, in my respectful view, are outside of his expertise, like the health effects of noise, since he's not a doctor? Are we potentially hurting the public by having them watch this testimony when they're so strongly supportive of this individual and they take what he says as true because they see him as an expert? And it's an interesting question that I think administrative tribunals might want to consider in the future when they're deciding how they deal with expert evidence. So with that, I think we're going to move on to the next case study or witness, and Terry Lee is going to take the lead on that one.
So this is a different proceeding. This wasn't a facilities application or anything like that, but it was in front of the AUC. And this past December, the AUC commenced a hearing regarding an investigation by the Market Surveillance Administrator, the MSA here in Alberta, against TransAlta relating to timed outages and trading at certain generation units owned by TransAlta. And also there was two individuals, a current employee and a former employee of TransAlta, that were also being investigated similarly. So this isn't a facilities public interest type determination. This is, I would say, getting kind of quasi-criminal, again, because it was based on an investigation. They were seeking monetary penalties. In the cases of the individuals, they wanted to restrict them from trading, which was their livelihood for a couple of years. So a very different scenario. And in that case, in the application by the MSA, they relied on a report by an individual who was the MSA's deputy administrator and chief economist, so employed by the MSA. And the MSA also proffered that individual as an independent expert to give expert advice in support of their application before the Utilities Commission. So if you think about that in a criminal context, it's very similar to the lead detective in a case also coming to present expert independent evidence relating to sort of causation and impacts of the alleged crime. So if you kind of think about it that way, that's sort of a similar analogy, I would say. So this individual who was employed by the MSA played a leading role in the MSA's 2-year investigation of TransAlta. During the course of the investigation, he authored and signed the notice of investigation. He interviewed TransAlta staff as part of the investigation. He was a contact person at the MSA for correspondence with TransAlta dealing with the investigation. He was in contact with and guided MSA staff in the course of the investigation, and he authored the report that the MSA relied on in bringing the matter in front of the AUC. So in its written submissions, which I think were just filed in January or February, TransAlta argued that the AUC should reject this individual's evidence or give it little weight. This is the expert evidence we're talking about. So in support of their position, TransAlta relied on the fact that he was the lead investigator into the allegedly impugned conduct, and that he had a vested interest in the outcome, ultimately, of the proceeding. So according to TransAlta, he was not independent, and as a result, his evidence was unreliable and should essentially be thrown out. So again, in its argument, TransAlta made the analogy to a detective in a criminal matter. In its reply, which was just filed a few weeks ago, its reply argument, the MSA submitted the individual was independent of any market participant, so independent of TransAlta, TransCanada Energy, Capital Power, that sort of thing. And he's only served the legislative mandate of the MSA and the development of a fair, efficient, and openly competitive market in Alberta, which is, of course, the goal of the MSA. And it went on to suggest that an expert body like the MSA, with a statutory mandate and the requirement to bring matters before the AUC, is prevented from utilizing that expertise in performing its statutory mandate due to bias. This was without foundation, was their argument. So that decision's still before the Commission. There hasn't been anything on that yet. It should be coming out soon. But anyway, just to kind of give you another example of the sort of expert issues that are playing out in front of the Commission. And we're representing TransAlta, so I'm not going to guess which way it's going to go.
And it's an interesting, from my perspective, each of the tribunals has their own practice directions and rules. The ERT has a expert direction, and it also deals with what they call technical experts. So not a actual independent expert who provides expert opinion, but someone who's considered to have technical expertise, and they specifically reference in the ERT practice direction government employees who were involved in the investigation. So there is, in my mind at least, the distinction between someone who gathers data in connection with an investigation and serves the role of a fact witness and provides information and processes it in a certain way to assist the tribunal, and somebody who's put forward to provide independent expert testimony. So I'm not deciding the decision that the case that Terry Lee just talked about, but I know where I would come out if it was presented to me, because I don't think that a lead investigator has the necessary elements of independence and impartiality to provide expert independent opinion evidence. We move forward then to Dr. Sarah Laurie, who testified, an Australian person who I was going to say doctor, but she's not qualified as a doctor, so I didn't. I couldn't say that. Sorry, Sarah. She testified in the St. Columban proceeding, also in the Platinum Produce proceeding, and here as well, I think Terry Lee in the Blue Earth case as well.
Yes, I failed to not have her qualified.
And so there was a difference in results between the ERT proceeding and the Utilities Commission proceeding out here in front of the AUC. She was qualified to provide opinion evidence of some sort.
Yeah, so Dr. Laurie, like Jim mentioned, is an individual from Australia who's proposing to testify via video conference or teleconference. And she wasn't a licensed physician, so she wasn't licensed to practice medicine and hadn't been for over a decade at the point in time when she was appearing before the Utilities Commission. And also she was the CEO of a foundation whose goal was to research health problems associated with individuals living next to wind turbines. So you might wonder again about independence when you're trying to consider whether something may cause an impact and you're the CEO of a foundation that just solely investigates the impact. whether or not you're necessarily independent. But at the point in time when she was seeking to be qualified in Alberta, she had failed to be qualified 3 times before the ERT in Ontario, and she was qualified in Alberta not long after that. So.
In the Ontario proceedings, she wasn't qualified because she wasn't a licensed doctor, and the thrust of the testimony she wanted to provide was about individuals she'd spoken to who claimed to suffer health effects from exposure to wind turbine noise, and effectively she was trying to provide an opinion that diagnosed them as having something called industrial wind turbine syndrome. And we said, look, she's not a licensed practitioner. She hasn't actually diagnosed anyone because she's not qualified to conduct a medical diagnosis. And if you let her evidence in, we're going to be days examining her about each of the people she says she spoke with. And the ERT accepted those concerns and those submissions and failed to qualify her as an expert. They did allow her to testify as a fact witness, but ultimately her fact evidence was all hearsay, and it was given because it was about conversations she'd had with people who claimed to have adverse health effects from exposure to turbine noise, and it was given almost no weight. So that was a result that helped shorten the proceedings in front of the ERT, because we didn't have to spend a full day with Sarah Laurie going through her opinion, and it was the right result. I think we would both agree.
Yeah, so just one additional comment to make. So the fundamental flaw, I think, in tribunals' approaches, particularly ones where in order to appear and participate in a hearing you need to have standing, which means you need to be a potentially directly and adversely affected person by that particular thing that's happening. The challenge is if an individual who purports to be an expert is put up on the stand, and then they give evidence, like fact evidence, like Jim was saying, that's either outside their range of expertise, or alternatively their expertise is given little weight. Why are they there, right? Like when I think about that, I think, why are they there? The only people that have a right to appear are those individuals that might be affected, those nearby landowners or Aboriginal groups that have passed the test, the legislative test for standing, and that the commission or the board or whatever regulator you're dealing with specifically wants to hear from, and they have a right to speak. So that's where I struggle a little bit with it. It's either people who are adversely affected or experts that they've retained to help them present their position. Experts shouldn't be giving factual evidence or any other sort of unexpert evidence, I guess, in front of a tribunal, because they simply don't have standing. So kind of think about how that might work.
Right. And we have one more case study, so to speak, that we're going to cover. And this one's an interesting one. It involves a witness named Dr. McMurtry. Dr. McMurtry is the recipient of the Order of Canada. He's a highly respected orthopedic surgeon who's now retired. He also happens to have a cottage in Prince Edward County where they are planning to develop some wind turbine projects. And he didn't want those projects to proceed forward, and spent a number of years investigating wind turbine noise and the alleged health effects on human health. As a result of that, he's been put forward in a number of tribunal cases as an expert witness, and he coined industrial wind turbine syndrome and put it forward as a medical case diagnosis, although it's never been accepted as such. He's an interesting case because he is a very well-respected doctor, but he's now trying to testify and provide expert opinion evidence that's outside his area of expertise, because he didn't spend his career practicing as an epidemiologist or as a occupational health and safety noise doctor. He's an orthopedic surgeon. In the Platinum Produce case, he was called in reply to provide opinion evidence about how one industrial wind turbine near a greenhouse could cause harm to the employees of that greenhouse. Ultimately, his testimony became a non-issue because he had some fundamental assumptions in his report about the level of noise in the greenhouse that were wrong, and that disqualified all of his evidence from having any impact on that basis. But it was an interesting case because when I was cross-examining Dr. McMurtry, I noticed that the opinion he'd expressed in the report that he had filed to the tribunal in the Platinum case was different from the 4 previous reports I had seen that he'd filed in other cases. It contained an unequivocal opinion that the wind turbines would cause harm to human health. And I'd never seen him do that before. He always said it was more probable than not. So I suggested to him that he actually hadn't seen his witness statement, his expert report, before it was filed with the tribunal. And remarkably, he agreed with me. He had actually not seen his opinion before it was filed with the tribunal. He also hadn't signed the required expert acknowledgement form, which the ERT requires you to sign, saying you're going to be independent and impartial. So on that basis, in this case, it was our submission that you couldn't qualify him as an expert. He hadn't read his report before it was filed. He admitted in cross-examination necessarily that his counsel had drafted it. He reviewed it only after it had been filed, and the opinion in his report overstated his actual opinion. And he hadn't signed the requisite expert acknowledgement. So that gets compounded with already a number of issues relating to his lack of impartiality and independence, including, I won't go into them in detail to save some time here, but including his involvement in various associations and communities within Prince Edward County. And so on that basis, we said that he shouldn't be qualified, and in that case, he was. Ultimately, as I said, his opinion didn't matter because he had some fundamental assumptions that were wrong and it didn't go anywhere. But it was troubling to me that with those circumstances, the ERT still let his opinion in. Do you agree?
I agree. Based on the summary I just heard, I agree.
It's
so
accurate.
Just to touch on one last thing before we finish up, and this is just kind of a little bit of a different spin on what we've been talking about. So everything we've talked about regarding experts has been their role in tribunals, acting, being retained on behalf of and acting for individuals that might be affected. So nearby landowners, or perhaps an Aboriginal group or a municipality or something like that. But there's one other instance where experts can act on their own, and that's in front of the National Energy Board. So the National Energy Board Act was amended through one of the omnibus bills back in 2012, and one of the amendments was a change to who can participate in a National Energy Board hearing, and that's section 55.2 for the keeners who want to go back and look this up after. But basically what it allows for, section 55, allows for individuals who may be potentially or directly affected to participate in a hearing. Right? So that's kind of the standard test across the board. But it also allows individuals who present themselves as experts, so essentially who have relevant information or expertise, to also qualify as interveners. So essentially, these are experts who aren't attached to anyone that's involved in the proceeding. They're just sort of independent experts. So in terms of its role as a gatekeeper, which Jim has talked about, and I think that was the gaming slide.
That was the slide where they were all getting through the gate.
Sorry.
Anyway.
So in terms of being a gatekeeper, how these individuals get into participate in an NEB process is they fill out a form, a very short form as part of the application to participate process, and that's it. There's no other qualifications or formal qualification of them. They simply indicate that they want to participate as an intervener. They have certain expertise. And the proponent can reply to this, but ultimately the NEB makes a ruling that determines whether or not they think that person should be granted intervener status or not. And that's basically the end of it. So the result is that you have experts who filled out the form who are participating fully in National Energy Board hearing processes. So they can bring motions, they can file evidence, they can file argument, they can file information requests of other participants, the whole sort of thing. And one might wonder why an expert tribunal like the National Energy Board with 50 years of experience and resources and all sorts of independent experts and the ability to retain their own outside independent experts would require someone to just apply to participate in a hearing. In a hearing that's currently going on right now, one of the independent experts who got intervener status on that basis has been the single most active intervener in terms of bringing motions before the board on that file. So you might question whether that person is necessarily, or other people are necessarily independent, or maybe they have an end in mind that they're kind of going for. But anyway, that's kind of an interesting twist, I think, on the whole intervener expert aspect. And one final note on the National Energy Board process is that they have a participant funding program. So individuals that qualify as interveners, so again, your landowners and Aboriginal groups can apply for funding to participate in the process. And this includes the independent experts. So by way of an example, you could have someone who's a biologist, say with a specialization in caribou, apply to participate in a hearing where a pipeline might cross through caribou territory. They might be accepted, and then they get funded to participate on no one's behalf. Not clear why they're there, and their qualifications generally aren't challenged. So that's kind of a different spin on it.
So we wanted to conclude with just some thoughts on we've talked about our experience and where we think perhaps adjudicators and tribunals should go. Each expert in each case may require its own specific consideration and analysis. There's different ways to do it. Our first rule, though, is that you've always got to make a ruling. You've got an obligation as a gatekeeper, if you're the adjudicator, to make a decision as to whether the expert opinion evidence presented to you is properly admissible, and or whether you're going to give it less weight because of some concerns that you have about it. So there have been cases where expert qualifications haven't been challenged, and there have been cases where they have been challenged, the tribunals have made no ruling on it at all, which we think shouldn't be a practice that continues. Second option, I guess, so I sort of see two ways that tribunals can deal with expert evidence. One is rule on admissibility at the outset, like in the case of Dr. Sarah Laurie that we spoke about earlier. That, to me, is, in these administrative hearings, you're trying to proceed efficiently. You've got a lot to cover. You have a lot of witnesses to get through. And you don't want to get bogged down in a voir dire every time there's an expert who's presented, where you have to hear the challenge of qualifications and then adjourn and rule on qualifications. That can really slow the process down. So you're not going to want to do that in all cases. But in cases where the evidence is sufficiently prejudicial or complex, I think those cases are appropriate when counsel insists that the tribunal then, in those circumstances, makes a ruling at the outset. And second would be a situation where the evidence that's at issue is going to significantly expand the scope of the hearing and take a lot of additional time. In those circumstances also, I think it makes good sense for the tribunal to make a ruling at the outset on qualifications. The other way to slice it is to rule on admissibility at the end of the hearing. So hear the challenge to it, but let the evidence in, and then rule on admissibility after you've heard all the evidence. That is an efficient and expedient way to proceed in certain cases. We've done it a number of times, and it's worked out just fine. And sometimes the challenge that you're making to the expert witness's qualifications will actually be interwoven with their opinion, like it was in the case of Mr. James. It was through cross-examination of him on the merits of his opinion that some of the advocacy statements that he made came out. And so in those circumstances, the tribunal can hear the evidence and rule on qualifications and admissibility at the end. But again, going back to the first rule, they need to make that ruling at the end. And it's important for precedential value as well that they make a clear ruling as to whether they're going to let the evidence in, and if so, whether they're going to give it any weight. And so far, it seems that our experience is that tribunals aren't consistently applying that rule. And so our thought is that it would be helpful going forward if it was applied more rigorously and more consistently. Really?
Yeah, the only other thing I'd add to that, and I think the challenge is if you have a ruling at the end, like Jim suggested in front of some regulators, someone still has to bear the cost of that individual, of that expert appearing throughout the hearing. And again, in front of the AER here in Alberta and the AUC, that's generally the proponent. Costs are claimed and costs are awarded. Although they might not get their entire costs that are claimed, someone has to foot the bill for the expert at the end of the day. So my view is that if there's serious challenges to their qualifications, their independence, that sort of thing, that should be dealt with at the outset before the hearing commences for cost efficiency reasons. But for the other reason too is I think fairness to the parties and fairness to the interveners. If interveners, again, and primarily in Alberta, interveners are landowners, nearby landowners. They're putting their money up to try to intervene on a project and present their views. If they're retaining a lot of experts, and at the end of the day, the commission's just gonna, or the regulator's just gonna let everyone in, and then at the end of the day, give them no weight, I don't think that's entirely fair either. If that's gonna be the way it's done, my preference, I think, would be that it's done at the outset, so everyone knows what the game is when they're coming into it. And also, there's also the opportunity for those interveners to obtain properly qualified experts. If all of their experts are gonna be disallowed or given limited weight, they still have that opportunity as well. So that's kind of a little bit of a different challenge in this jurisdiction, I think.
So that concludes our comments. If there are questions, we're happy to take them.
We have about 4 minutes. Are there any questions? Do you want to read it or you want me to?
Doesn't matter.
Okay, so this is a question from the auditor.
Hi, I appear regularly at the Quebec Régie de l'Énergie for interveners. The Hydro-Quebec Council regularly attack the independence and qualifications of our expert witnesses. On the other hand, the Utilities panel of witnesses regularly give opinions on all kinds of topics, e.g. the potential advantages in terms of reduction of energy consumption, not just efficiency, of changing the rate structure for industrial or residential electricity customers. So all kinds of opinion is allowed in the mouth of putative fact witnesses, while the rules regarding experts are used to try to limit the scope of the inquiry into what should be a polycentric public interest process. This panel has no balance and tells us who is not an expert, not who qualifies. I also find it very inappropriate character assassination of witnesses, even in cases under reserve. It would be nice to have panelists with perspective that comes with more than 10 or 15 years at the bar, frankly. Well, Franklin, thank you for your opinion. I wish I'd read your comments before I read them out loud. I will respectfully disagree, but hope you do better in your future hearings.
Maybe I'll move to the question on the card. So the question is, if a ruling or decision finds that an expert was acting as an advocate, can the expert be found in contempt? So that's a good question. I think the answer is only if they lied under oath. My experience has been when you ask these individuals if their organization they're a part of is an advocacy organization, they'll say yes. Has been my experience. So if they lie under oath, I think that would be a different issue, but I haven't seen that so far in my career.
Yeah, I've not seen an expert held in contempt, although I have seen some very stern judgments admonishing experts for not being properly independent. And if you're an expert witness, if that happens to you once, you're toast, because someone will find that decision and they'll refer the trier of fact to it the next time you testify.
So the first question here, I'll do the first one, you take
Sure.
the second one. So why are proponents so reluctant to challenge participant intervener funding for unqualified, biased experts? So that's a good question. I think there's a variety of reasons depending on what the project is and who the proponent isn't. In this day and age, corporate social responsibility and being a good neighbor, those sorts of things are very valuable, and companies, I think, take a lot of pride in their approach to neighbors, and often it can be, I think, seen as being aggressive or maybe a bit unfair if a proponent challenges interveners' experts. So I think that might be one reason that they do that. I think that's probably the primary reason, realistically.
And the other part of the question is, what about, quote, lay experts armed with volumes of internet research?
Oh.
So that's something we've seen a lot of. People coming forward who aren't experts but have read a lot of information on the internet, and they want to be qualified to provide their views based on what they've read. And I think the general practice in front of the tribunals is to allow that evidence in, but the weight that's given to it is usually quite low because someone's just repeating what they've read on the internet. And so acting for proponents, I'd like to see a different process to shorten the hearings where that kind of evidence isn't allowed, because ultimately it's not given much weight. But at the end of the day, these are public hearings as well, where people need to feel that they've been heard. So it's a compromise, I think, that's been made.
I have to give one example from the trenches. I was once cross-examining a witness who his reference for one of his opinions was Wikipedia. And the kind man even spelled it out for me. He said www.wikipedia.com. I said, thank you. So.
We are on the comment that we got, the first comment that Jim read, we are tomorrow going to be talking about the challenges that individual groups have in getting experts. And one of the questions was about intervener funding. Ontario closed its intervener funding project which many of us started in 20 years ago with landfills. And when they did that, you started to see the very issues that we're seeing in the tribunals. When you don't have funding, in my view, for experts, then you have to resort to people that are perhaps more advocacy people because of lack of funds. And so that raises another issue that I think we're going to talk a lot about tomorrow. So hopefully that will address some of the individuals' concern. We have one final question from Montreal. Do you agree that limiting the range of input compromises the capacity of tribunal to benefit from having the best information? What's your view on the recent NEB rules narrowing the range of those who qualify as parties or interveners?
I'm going to go first.
Please.
So I don't think the NEB has narrowed who qualifies as interveners. That's not my reading of the legislation, and that's not been my observation in terms of interveners. What was the first part of the question?
Does it limit the quality?
Oh yes, does it limit?
Yeah, the quality of information.
Yeah, so I mean, if you are an intervener, you can provide whatever information you want to whatever regulator it is that you're appearing before of. Period. As long as within the scope of the proceeding. So you can't talk about something that's completely irrelevant, but you can provide whatever views and what information you want to provide. If you're an expert, you're not given that flexibility. You are there to provide opinion evidence based on your area of expertise. So I don't think that limits the sort of information that's provided to a panel. And also, the other thing to keep in mind is you can bring in an expert to testify on any area that's within the scope of the proceeding, so long as they're qualified to do so. So I think all that information still makes its way in front of a panel.
I'm going to, Jim, have to cut you. So
fine.
I will ask everyone to give them a round of applause. And we're going to move on. I mean, I think why we wanted to start with this was to give you a view of the trenches and where expert evidence is coming in my view as well, in great amounts. And so what we thought we'd do is then bring it back to what does the law actually say? So Gary and Andrea are now going to move on to an overview of what expert evidence, of what the case law is on expert evidence, and bring it back more to what the law says. And then we're going to go full circle. We're going to go more practical after that with a bit of a mock cross, as well as we're going to look at how do you prepare an expert. So we're going to go from the trenches, as we heard from Terry Lee, to more of an academic look at the law, and then full circle to practice. So there's where we're going to try to hit. So no one gets confused with there.
Me.
Sorry. There's
So-
Andrea. Thank you.
This afternoon, Andrea and I are going to talk about the admissibility requirements for expert evidence, both in the courts and administrative tribunals. And here's the theme of our presentation. The theme is it's not impolite to object to the admissibility of expert evidence. It's standing up in front of a tribunal or a judge and saying, the Supreme Court of Canada said something about this. In Moen, and 3 or 4 cases after that, there are 4 criteria, and within them sub-criteria. And if this evidence does not meet those criteria, either as a matter of law in a court, you cannot hear this evidence, or as a matter of persuasive substance in an administrative tribunal that's not strictly bound by the rules of evidence, you should not hear this evidence. So why do we say it's not impolite to object to the admissibility of expert evidence? We say that because the Supreme Court of Canada has indicated, to my mind anyway, that it's uncomfortable with expert evidence. It sees clearly the sort of mischief that the panelists that have preceded us have spoken about. And it is concerned, the Supreme Court of Canada, even in a trial process, about expert evidence overwhelming the process. Now, if that's true in a trial with a judge wearing a gown, How about an administrative tribunal or a public hearing? Now, we all know, at least you might not accept, in my view anyway, public hearings of environmental issues are an important and vital part of good decision-making in Canada on environmental issues. But if hearings get out of control, if expert evidence and others overwhelm the issues, then this important part of decision-making can suffer in credibility and acceptance. The issue of overwhelming that the Supreme Court of Canada is concerned about has practical effects. We've all seen it. We just heard about it from the last speakers. And in R versus D&D, which followed Moen, Mr. Justice Sapinka said, Mr. Justice Major from Alberta, I shouldn't get his name wrong in this province, said, in Moen, Sapinka J stated that the need for expert evidence must be assessed in light of its potential to distort the fact-finding process. And one can easily form the view that the practice in the courts and administrative tribunals is not in accord with what the Supreme Court of Canada is saying or what the Ontario Court of Appeal said in R versus Abbey or what the BC Court of Appeal said this week in R versus Orr. And of course, and in fact in Abbey, what the court said is that expert evidence, expert opinion evidence, is presumptively inadmissible. It's not that anybody stands up and, regular witness stands up, so they're presumptively inadmissible. And that doesn't mean it's necessarily inadmissible. It means it's presumptively inadmissible. It means that the person, the party proffering the expert must bear the burden on the balance of probability of establishing that the evidence is admissible. And how does that happen? That happens by applying the Abbey factors as they have been massaged since. Now, in proffering evidence or in, more likely in objecting to it, there are basically two approaches as advocates. One is what you should do, I suppose, a rigorous analysis of what the law tells you the factors are. The other is to select out, and we'll refer to some of them, some of the very powerful statements from the Supreme Court of Canada, standalone statements that will cause any fact finder, adjudicator, to have some pause. So, Moen, as we'll get into, introduces 4 criteria for admissibility: relevance, necessity, the absence of any exclusionary rule, and a properly qualified expert. There are some other factors that are in the mix. What goes to admissibility and what goes to weight. There's a nice line from the Supreme Court of Canada on that issue. Reliability, Andrew is going to talk a bit about that. The gatekeeper function, which we've heard about, which is a cost-benefit analysis weighing probative value over prejudice. That gatekeeper analysis in Moen is alive in other Supreme Court of Canada jurisdictions. R versus Hart, which was decided last year, a Mr. Big confession case, applied this year again. And a case decided yesterday. This balancing of probative value over prejudice is a very live issue in the Supreme Court of Canada. And Moen, in cases that have nothing to do with expert evidence, is referred to often in those cases. Independence, impartiality, and objectivity that we just heard the last speakers talk about. Very important issue that was touched upon a bit in the Ontario Court of Appeal case that we'll hear about some more, and Andrea will touch upon. Big deal in Ontario, that case. But was squarely raised in a Nova Scotia Court of Appeal case about an alleged conflict that a witness had. And what's important about that is the Nova Scotia Court of Appeal case, which is a summary judgment application, has been argued not only has been given leave, it's actually been argued before the Supreme Court of Canada last fall, and we should have reasons, I would expect, in the next number of weeks from the Supreme Court of Canada on the issue of independence, impartiality, and objectivity. There are diametrically opposed reasons for judgment in the Nova Scotia Court of Appeal on that. The majority, this is actually Andrea's point, but I couldn't help mentioning it. The majority reasons, and you have to read all the reasons in fairness to the court, but the majority reasons start with these two sentences. Partial witnesses testify in courts every day. If impartiality and independence were necessary attributes for a witness, there would be no litigation. So, and then in careful reasoning, I didn't take it out of context because those are the first two sentences, but it's certainly not the context of the whole. But it does lead you to the result, and the Supreme Court of Canada is going to have to come to grips with that, as basically whether a perception of bias is presumptively disqualifying for a witness. The terms impartiality, independence, and objectivity are dealt with separately in those reasons. We can expect the Supreme Court of Canada will get into that. So we've posted a paper that you can look at with some more references. After after expert opinion evidence, we're going to talk a bit about expert lay evidence that Andrea will talk about. A case in BC, the Bette Midler case, which she'll talk about for a bit, which takes us to, if you are looking to admit expert evidence, what should you be thinking about in the environmental law context? And that is what we've called the Big Four, the first of which is selecting the question. Selecting the question with respect to which the opinion is sought. Very important, and not that simple in the line of work that we have. For the most part, environmental law issues are statute-driven. That's the case in prosecutions, in environmental assessment litigation, and in statute-based contaminated sites litigation. As such, the first question for counsel is what statutory requirements must be established or disproved, and what, if any, expert evidence, if available, may be helpful in order to meet that burden of proof. The earlier that this process occurs, the better. And of course, what flows from that, the theory of the case, is what is the precise question that you want the expert to answer. And you might take a moment, I'm sure everybody does here, to ask yourself, why am I asking that question? And if it's answered, how does that help me? That's important. And it's self-evident, but it is important, and we've all had experience, hopefully not ourselves, where that question hasn't been asked. So the next of the Big Four is qualifications. In the environmental law context, and that is one of the Moen factors, but we're going to deal with it just up front here. A lot of these things are self-evident, but it's only self-evident once you've thought about it and expressed it. That is, it's not enough that the person selected to provide the opinion is an expert in his field, even a renowned expert. He has to be an expert in what it is that you're asking he or she to testify on. And the Supreme Court of Canada has remarked upon that. They are very concerned about constraining what the expert says to what the expert is an expert in, both at the time of admissibility and throughout the hearing process. Very strong words about that in the Supreme Court of Canada cases. So, an expert hydrogeologist experienced with groundwater flow dynamics may well not be an expert in toxicity issues related to that groundwater. And that seems self-evident, not always followed. And that, putting the right cases to a tribunal of any sort is powerful. This person may be an expert, but not an expert on what they are being put forward to help you with. As stated by the BC Court of Appeal earlier this week in R versus Orr, an expert must not only be qualified generally, but must also be qualified to express the specific opinion proffered. So that then takes us to assumptions. A report is only as good as the assumptions that underlie it, that are proven. Again, in a statement that is self-evident, but very powerful, in my view, in front of a judge or a tribunal, Benny J. in R versus JLJ in the Supreme Court of Canada said this: before any weight at all can be given to an expert's opinion, the facts upon which the opinion is based must be found to exist. Before any weight at all. That is pretty powerful. That is a pretty powerful statement to give to a tribunal at the end or the admissibility stage and say, ignore this. This is worthless. And if you don't believe me, this is what the Supreme Court of Canada has said the law is. So the next is the Moen factors, which is admissibility. And now, there is a certain lack of clarity of when the gatekeeper functioned, what we just heard about from the last presentation, when that comes into play. There is a view that, from R versus Abbey, that the four Moen criteria, which again are relevance, necessity, absence of an exclusionary factor, and qualifications, those are basically preconditions. And if you get through there, then you come up to the gate. And there the judge has a discretion as to whether to admit the evidence based on other factors. That's not quite what Moen says, and it's not quite what a case following Abbey, that is, following it chronologically, in the Supreme Court of Canada says. Gatekeeper may be all rolled into relevance. So what I'm going to talk about a bit is the two interesting factors of the four, which are relevance and necessity. And relevance means more than relevance. When it's clear the heading in Moen is relevance, but it's broken down in Moen to logical relevance and legal relevance. And logical relevance means relevance, means what I understand, you understand as relevance. It's, connected in a way to the inquiry. But that's not enough. What the court said in R versus JLJ is logically relevant. It means evidence is relevant where it has some tendency as a matter of logic and human experience to make the proposition for which it is advanced more likely than that proposition would appear to be in the absence of that evidence. That is, it means it's relevant, to shorthand that. Moen and R versus JLJ went on to say that logically relevant evidence, what I just discussed, may be excluded if its probative value is overborne by its prejudicial effect, if the time required is not commensurate with its value, or if it can influence the trier of fact out of proportion to its reliability. So we got this concept of reliability. Andrew will talk to you a bit about that. And we've got this idea of overwhelming the process. And there's a couple of things that I shouldn't say this in a public hearing, but I say this with great respect. The Supreme Court of Canada judges aren't stupid. They get this, and they understand that there's a couple of things happening. One, that it's not up to the trial judge or administrative tribunal hearing to take what an expert says and as truth. the expert evidence has to be presented, and the court has made this clear, in such a way that the trier of fact can make an independent judgment as to that. And the starting point there is understanding the evidence. The evidence has to be comprehensible to a trier of fact, which is sort of two elements to that. One, an expert shouldn't testify if what he is saying is so simple that a trier of fact doesn't need help, because expert evidence is supposed to explain complexity. So if it's too simple, you don't need expert evidence. But if it's presented in a way that's turgid and complex and is not subject to really independent review, then it shouldn't be admitted for that basis, because it's not there to help the trier of fact. It's there basically to be a fait accompli. And then there's the issue of the side issues that expert evidence, and so the court looks as to whether, to some degree, not just the evidence, but the issue, whether it's important enough to the hearing process, commensurate with the time that it's going to take. And there's some nice lines. What Binney said in R versus JLJ, Mr. Justice Binney, the possibility that such evidence cloaked under the mystique of science would distort the fact-finding process was very real. Moreover, defense evidence of this type can be expected to call forth expert evidence from the Crown in response, with a consequent danger that the trial could be derailed into a controversy on disposition or propensity, which was what the issue was there, with the trial becoming nothing more than a context of experts, with the trier of fact acting as a referee. And in the recent case, Hart, applying Abbey, the Supreme Court, that was last year, quoted from Abbey to say, when one looks to potential probative value, one must consider the reliability of the evidence. Reliability concerns reach not only the subject matter of the evidence, but also the methodology used by the proponent expert in arriving at his or her opinion, the expert's expertise, and the extent to which the expert is shown to be impartial and objective. Now, the Nova Scotia Court of Appeal case, it doesn't say that impartiality, objectivity is irrelevant. It just says it's not presumptively disqualifying. And then the court is clear in the second, the Supreme Court of Canada said, quoting from Abbey, a cautious delineation of the scope of the proposed expert evidence and strict adherence to those boundaries, if the evidence is admitted, is essential. The trial judge must both ensure that an expert stays within the proper bounds of his or her expertise, and that the content of the evidence itself is properly the subject of expert evidence. And that takes us then to necessity. And necessity, the court is very clear, it's not enough to be helpful. Helpful doesn't help. It must be necessary. And there's an interesting little nuance. In Moen, the court said just what I said, and then went on to say, but I don't want to hold too high a standard for necessity. And in all the cases that I've seen in the Supreme Court of Canada since Moen, they've quoted basically, it's got to be more than helpful, it's got to be necessary. The last little thing, I don't want to have too much high a standard for necessity. I don't see that quoted. So it may be that the court now is moving towards necessary means necessary. And you know, what does that mean in R versus JLJ? The expert's duty is to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of the conclusions so as to enable the judge or jury to form their own independent judgment. The purpose of expert evidence is to assist the trier of fact by providing special knowledge that the ordinary person would not know. Its purpose is not to substitute the expert for the trier of fact. What is asked of the trier of fact is an informed judgment, not an act of faith. And then, I'm not going to read it out, but there's a very good quote in R versus DD that talking about the risks associated with an expert basically snowballing over the trier of fact. And the court has said a number of times, and perhaps not with anybody here in mind, but they've said basically experts are really tough to cross-examine, and you can expect cross-examination to be effectively undertaken of experts. I mean, they said that without knowing the people here, but that is one of the factors of being careful about introduction of expert evidence, because at the end it has to be tested in order to be useful to the court, and the tool of cross-examination, they're concerned about it being useful. I'm going to leave you, just so Andrea has some time, I'm going to leave you with one last thought, and that is, well, what do all this law mean in front of administrative tribunals, some of whom have their own rules, which are quite rigorous, some of whom are bound by the general law, which basically, or the statute that sets them up, that says they're not bound by the rules of evidence. So what does not bound by the rules of evidence mean? Well, a 2013 case in British Columbia, Mr. Justice Gopel, BC Lottery Corporations versus Skelton, said, what the commissioner had to decide was whether or not the report met the Mohan criteria. If it did, it was then admissible as expert evidence. If it did not, given the relaxed rules of evidence in administrative proceedings, she could, at her discretion, admit it in any event. So what the judge was saying is basically, if evidence, this is the law in BC, if evidence meets the Mohan criteria, it has to go in. If it doesn't meet the Mohan criteria, maybe it goes in anyway. And again, as I said at the beginning, in my view, I think it's a strong argument to say that it may well be that administrative tribunals are bound by the Mohan rules as some sort of fairness issue, jurisdiction issue. But even if they're not, the Mohan rules are powerfully persuasive because they're principled. And the principles that the Supreme Court of Canada adopted should be persuasive to administrative tribunals as well. Andrea, sorry. Yes.
So I'm going to start off talking a little bit about novel scientific theory and expert opinion within the Mohan criteria. Then I'll move on and talk a little bit about lay opinion evidence in the very interesting Bette Midler case, quite colorful, recent BC decision. And then I'll finish off by touching on the what Gary talked a little bit about, the Nova Scotia Court of Appeal and the imminent decision from the Supreme Court of Canada on independence, impartiality, and objectivity of experts. So starting with novel scientific theory or technique, as Gary said at the outset of our presentation, our theme is that it is not impolite to object to the admissibility of expert evidence. And it's perhaps obvious that one very fruitful ground for objection is expert opinions based on novel scientific theory. This is an area that could present counsel with a long shopping list of issues that can be raised to challenge the admission of that expert opinion. And Gary's already gone through a lot of those factors that would be applicable to novel scientific theory. It's, again, not surprising. R.V. Mohan is the starting point if you have an issue with novel science. And in fact, it's of interest to me that Mohan actually was a case dealing with novel scientific theory. And what has happened there is the criteria that were developed by the Supreme Court of Canada have become rules of general application for admissibility, but we shouldn't forget that that's the starting point, that case, if you have novel scientific theory, expert opinion, then you start with Moen. And the key there, what was said by the court, is that novel expert opinion evidence based on novel science is subject to special scrutiny and must satisfy a basic threshold of reliability. And that will then lead to the question, well, how do I determine what the basic threshold of reliability is? And Moen nicely sets out the 4 criteria, which Gary has canvassed, but didn't help us a lot on exactly what the threshold is for reliability with respect to novel scientific evidence. I would commend you to actually read through the entire case, because at the very end there's 2 paragraphs where the court does give us some clues as to why they agreed with the trial judge decision that the expert evidence in that case was properly not admissible. And just to flesh that out a little bit, the novel scientific evidence in that case was character traits of the accused and whether those traits fit a psychological profile of the perpetrator of the criminal offenses in that case. And again, you have to read to the very end and get these hints from the court. In that case, there was nothing to indicate that there was a general acceptance of the profiling theory, and that those words are important. They come up in later Supreme Court of Canada cases about the threshold reliability. There was no standard profile developed, meaning in the scientific community, with respect to an offender who commits that type of crime. And lastly, the last fatal flaw was that the expert in that case had done interviews of a very limited group of offenders to develop his own list of characteristics. He interviewed 3 subjects, and that was just found not to be an adequate basis on which to develop a list of characteristics. So moving on from Moen, if you're faced with this issue, the next important case is RVJLJ. Gary also mentioned that. Again, that's a case that was dealing with reliability of admissibility of novel scientific evidence and expert opinion. Not surprisingly, RVJLJ applied the Moen criteria, but is a little more helpful on the concept of what this threshold reliability means. The court, interpreting Moen, said that Moen rejected a general acceptance test. If you read the cases, this comes from US case law, meaning that the theory has to be generally accepted within the scientific community in order to be admissible. So Moen is said to reject that. And then it is then said that Moen accepted or endorsed what's called a reliable foundation test, which was set out in another famous US case called Dobert. And then in RVJLJ, the Supreme Court focused on those Dobert factors and said that they could be helpful and could be helpful. They're not the end-all be-all, but they could be helpful in evaluating the reliability of novel science. And just quickly, those Dobert factors really go to the scientific method. So whether there's four factors, whether the theory or technique can be and has been tested, whether there's been peer review and publication with respect to those theories and techniques, the known or potential rate of error or the existence of standards. And finally, again, here are these words we keep hearing, whether the theory or technique has been generally accepted within the scientific community. Again, important that the court did not limit the determination of this threshold reliability to these four factors. It depends on the case. Just to draw back a little bit and remind us, RVJLJ summarized, I thought, very nicely the criteria for reception of novel scientific evidence. And going back to the touchstone of Moen, relevance, necessity, reliability, remember that's the focus for novel admission of opinion evidence on novel scientific theory, but then going back to what the presenter said before us and Gary's discussion, then the gatekeeper analysis is still relevant. So relevance, reliability, and necessity all have to be measured against the cost-benefit analysis. That is consumption of time, prejudice to the trial process, and potential confusion that could be caused by admission of the evidence. So that's the starting point, Moen and RVJLJ. An interesting case, a case that I thought was interesting, is a recent BC Supreme Court case. It's called, I guess I should flip ahead here, if I didn't turn it off. This Taylor and Leon case, which discusses in a little bit more detail the threshold reliability issue, but really went a long way down the road and paid particular attention to distinguish threshold reliability from what they called ultimate reliability. And I recall what was said this morning in the discussion about causation. And what the court was careful in that case was to draw some limits around the assessment of threshold reliability. The court is not being tasked to determine whether the opinion evidence will prove or disprove the party's case at the stage where the admission of the evidence is being challenged. That is for later in the trial process, if it actually is admitted. And the neat thing about the Taylor case, I thought, there's two sets of reasons. The first set of reasons are out of the voir dire, where the plaintiff's expert evidence, they sought to tender 4 expert reports, and they were all challenged on the basis that they were unreliable based on novel scientific evidence. The court admitted 3 out of the 4 expert opinions, and then in the next decision, which was about a year later, sort of procedurally, it's odd. I can't explain the gap in time there, but the court then went on to apply the ultimate reliability, what they called the ultimate reliability test, which got into the causation and found, in fact, that the plaintiff did not prove their case. The novel expert opinion evidence did not establish causation. So moving on to one further, moving on to the last case that you should, I call this the trilogy of cases, RV Abbey. I think I'm getting a little bit short on time, so just quickly, the reason that RV Abbey is important and requires some thought, it talked about novel, non-scientific evidence and recognized that those Dobert factors that were endorsed by the Supreme Court of Canada in RVJLJ might not fit the reliability assessment for example, behavioral science or social science. So they said you can't limit yourself to that. You have to be a little bit more flexible in that area. And to bring this back, this is all very black letter law, but to bring it back to what we're talking about in the environmental law context, there's a lot of art and science that engineers bring to the table. And Gary earlier talked about hydrogeologists. So I'll use that example again. And a hydrogeologist often makes inferences as to groundwater flow path. Part of that opinion may source from years of experience. Part may be based on scientific principles with respect to the methodology of groundwater flow. And the years of experience part sort of fits into the Abbey perspective. And that expert opinion evidence, if it's novel, may still be admissible given the years of experience of the expert applying their observations. And just mention 2 more cases, 2 BC cases that admitted novel scientific evidence, expert evidence based on years of experience rather than sort of scientific methodology. One is RV Aitken, and the other is fairly recent 2012 BC Court of Appeal case, Castles and La Dolcetta. But again, the La Dolcetta case, the expert in that case, she was a medical doctor, had 30 years of experience, and while her opinion referenced inconclusive literature on the issue, the court found that was not the death knell for her report. Rather, she had 30 years of clinical observation, and the evidence was admitted on that basis. So quickly, lay opinion evidence. The leading case in Canada is R.V. Grat. It's a 1982 decision of the Supreme Court of Canada. It's been cited many, many times. I'm just going to get to the heart of what that case says, is that lay opinion evidence, it's generally excluded. It can be admissible in limited circumstances, and as I would put it, it's basically a summary way for the witness to give their impression of an experience that we all share. For example, intoxication is sort of the classic example. It may be difficult for a lay witness to parse out, well, exactly what it was that led me to the opinion that this person was intoxicated. Perhaps a room full of lawyers might be better at that, slurred words, unable to walk, spilling drinks, that kind of thing. But it's a summary way just to say, yeah, I observed this person, they were intoxicated. And there's a very colorful recent BC case. It's a case involving a Bette Midler impersonator. I think that case, I won't get into it, but it demonstrates a continuum on the admissibility of lay opinion evidence. There were 3 categories. I think the court got it right with respect to 2 categories. The category in the middle, I'm not sure. And that's where the lay witnesses were giving their opinion as to whether this person was a good Bette Midler impersonator.
What was admitted? Tell her what was admitted.
What was admitted was whether this person was a good singer and had energy, was a good performer. And I think that's probably right. We all in this room can probably make a good assessment of that. Whether someone's, a good Bette Midler impersonator, maybe that person needs to have some experience. What was clearly inadmissible was whether she was going to make it, whether she was going to be successful. And the court got that right. They said that required expert opinion. So I'm just really quickly gonna wrap it up here. Gary's already mentioned the Nova Scotia Court of Appeal on independence, impartiality, and objectivity. We have alerted you that case is coming out any day now, and we haven't talked about the very recent Ontario Court of Appeal decision in Moore and Gatineau, which I don't know if I'm saying that right, but dealt with the issue of counsel communication with experts. And I just checked on the Supreme Court of Canada website this morning, and so that case, the Ontario Court of Appeal decision, came out after the Nova Scotia Court of Appeal case was argued. Counsel for one of the parties wrote to the Supreme Court of Canada to alert them to the Moore v. Gatineau decision, so perhaps those factors will play a part as well. So just so you have the name of the case, it's Abbott and Halliburton Company versus WBLI Chartered Accountants. It was a really interesting read. I recommend it to anyone. And the other interesting case on independence, impartiality, and objectivity, specifically in the environmental context, is a 2006 decision out of Ontario, RV Inco, where an employee of the Ministry of Environment was said not to necessarily be not independent, and their evidence was admissible.
We have 1 or 2 minutes if people want a question. Is everybody looking for coffee? Okay, well then a big round of thanks. Thanks